Hello and welcome back to RR Corporates. Today we are discussing a crucial NCLAT ruling dated 6th May 2025, very recent one, which set aside an NCLT order of liquidation delivered without notice to the resolution applicant or any reasoned findings. So this decision underscores two fundamental pillars of the insolvency and bankruptcy code. One is the primacy of a committee of creditors. Second one is the principles of natural justice. Let's dive into what happened, why the NCLT's order was flawed, and what the NCLAT directed. In this case, Company Appeal 80, INS number 183 and 446 of 2024, the appellants had submitted a resolution plan worth of 77.98 CR, which was duly approved by the CoC with 98.15% majority. So the resolution plan included 5 movable properties as a source of funding. One of them being a Girgaon property owned by the appellant number 3, Mr. Parag Malde. However, SBI, State Bank of India, objected to the resolution plan. They claim that was a title dispute over the Girgaon property, which was worth just 90 lakh rupees. So only 1.5% of the total resolution value. This is what the claim of the SBI. So they are saying that there is a dispute on the title, which is valued around 90 lakh. So SBI unilaterally withdrew the consent to the resolution plan and alleged a fraud against the applicants. So based solely on this, NCLT Mumbai Bench rejected the plan and ordered liquidation without issuing notice or allowing the appellants to a chance to respond. So the appellants challenged the NCLT's order before the NCLAT. Their key arguments were: no application under section 33(2) of IBC was filed by SBI for liquidation. Number 2, the NCLT passed the order without any show cause notice, hearing or reasoned decision. Number 3 is the alleged fraud had not been adjudicated upon. Number 4, the Girgaon property represented only 1.5% of the plan value. So, and they had offered to replace it with a 1 crore fixed deposits. So these are all the challenges. So the appellants challenged the NCLT's order before the NCLAT. These were the key arguments. So NCLAT findings, the NCLAT bench comprising Justice Yogesh Khanna and Mr. Ajay Das Mehrotra made several important observations. The first, the NCLT's order was a non-speaking order. It lacked reasoning. And second one, no notice was issued to the resolution applicant, violating natural justice. And third, SBI's withdrawal of consent was unilateral and not backed by the CoC. And fourth finding, there was no adjudication on the fraud. It is made by the allegation made by SBI. So importantly, NCLAT emphasized the CoC's commercial wisdom cannot be disregarded lightly. When a resolution plan is approved with 98.15% votes, courts should not substitute their own views without present reasons. So the directions by NCLAT, the NCLAT set aside the NCLT's liquidation order and remanded the matter back to the NCLT with a clear instructions, issue proper notices to the appellants, provide them a chance to respond to SBI's fraud allegations, pass a recent order after full adjudication, complete this process within 8 weeks from the date of the appearance. So this sets a strong precedent for procedural fairness in insolvency proceedings. Legal and practical implications with this order. The judgment carries major implications. First, the resolution applicants have Enforceable procedural rights. No order rejecting their plan can be passed in silence. And second one, the financial creditors cannot act unilaterally, especially when CoC has already noted. NCLTs must provide speaking orders explaining why a resolution plan is being rejected. Fraud claims must be adjudicated, not just presumed. So it strengthens the rules that IBC is not recovery tool, but a resolution framework based on stakeholder concerns. So the conclusion and takeaways are, to summarize, the NCLAT rightly restored a balance in this matter. Due process and natural justice cannot be sacrificed at the altar of haste. The CoC's commercial decision deserves a respect unless there is a clear illegality. So the ruling will influence how NCLTs handle objections and reinforce judicial discipline under the IBC framework. If you found this analysis useful, give us a like, share this with fellow professionals, and subscribe for more real-time updates on insolvency and company law in India. Hit the bell icon to stay notified and latest links that matter in your practice. Thank you. Please subscribe to RR Candidates, and we have other channel, RR Legal Talks. Thank you.